Well, good morning. Ladies and gentlemen, distinguished guests, His Excellency Mr. C.B. George, Ambassador of India. Okay, we don't have Mr. Minister of Economic and Commerce of the Indian Embassy, Ms. Devjani Chakrabarti, and esteemed colleagues. Namaste. It is with great pleasure and profound excitement I welcome you to this business investment seminar with a focus on recent trends and investment opportunities for Japanese companies in India and taxation and disputes resolution in India. This initiative to promote understanding of the Indian tax and legal landscape is brought to you by the Indian Embassy in Japan and JSA, a leading Indian law firm with a pan-India presence and standing for more than 30 years with a focus on corporate disputes, taxation, and finance. I now invite the Ambassador of India to Japan, His Excellency Mr. C.B. George, to give his inaugural address to commence this seminar.
Good morning, everybody. Shri Upendra Gupta, Corporate Partner, JSA, Mr. Rio Okachi, Partner, Anderson Mori, and Tomotsune, esteemed panelists on today's discussions, ladies and gentlemen. Good morning to you all. I would like to, first of all, welcome each one of you for this excellent seminar, the Business Investment Seminar, Taxation and Dispute Resolution Mechanism that we are organizing today. I thank JSA for the initiative in putting together the program today. When we talk about India-Japan investment relationship, we see a huge momentum in recent years. I recall the transformation that has taken place in the last few years in our relationship. To give you an example, during the G20, which we presided last year, India organized 200 meetings in different parts of India. That means 200 delegations from Japan participated in that meetings spread all over India. And when they came back, they came with one message: India has changed. What we saw in India, it's a new India. So they understand, our Japanese friends understand and appreciate the changes that have taken place in India in the last couple of years at every level. In my last one and a half years in Japan, I had a great opportunity to travel across this beautiful country. Everywhere that I went, I see a momentum for India-Japan relationship. Everyone is getting aware of the changes that have taken place in India, not only in business, but also in digital transformation, in scientific changes. For example, the Chandrayaan mission, the moon mission, that has sent a clear positive message about India's scientific achievements to every corner of Japan. So I see a momentum for India-Japan relationship, a momentum for fully utilizing the opportunities that emerge in India. I can see it in Japan. And we can be very proud that we were able to bring in a lot of changes in our system in the last few years. Despite the challenges of COVID-19 pandemic, we were able to continue with the reforms program. We did not stop. We continued the reforms program. The ease of doing business has changed completely in favor of to generate a further momentum in our relationship. Today India offers a very favorable tax regime characterized by simplified compliance procedures and various incentives to promote investment and economic growth. The corporate tax rate has been reduced progressively with a range of tax initiatives, especially for newly set up manufacturing units, such as the low tax rates of 15%. This has made India an attractive destination for businesses seeking to establish their operations. Several policy reforms, such as liberalization of FDI norms, streamlining of regulatory procedures, and promotion of ease of doing business, have been implemented to facilitate the success of Make in India campaign. The PLI scheme is one example. Today, I'm very happy that we have an eminent panel of speakers from leading Japanese and Indian law firms and consulting firms to deliberate on these reforms and provide you with very interesting insights. I wish the meeting all the success. I am sure that this meeting would be another brick in building our edifice of India Japan partnership. Thank you and good morning.
Thank you, His Excellency, the Ambassador of India. Uh, the first panel today is the panel on recent trends and the investment opportunities in India for Japanese companies. And the distinguished members of the panel are Ryo Okochi. He's a partner at one of Japan's leading law firm, Anderson, Mori and Tomatsune. He is a pioneer amongst the legal professionals who endeavored to bring India and Japanese business entities together by offering his expertise in cross-border legal matters. He has expertise in cross-border mergers and acquisitions, joint ventures, and corporate restructuring. His practice focuses on transactions related to emerging countries such as India and ASEAN countries. His experience includes a stint in India, working with a reputed Indian law firm, and advising on countless matters dealing with investments in India. May I request Mr. Ryo Okochi to come on stage? Our second panelist is Mr. Sunny Goel. He is a principal and group head, Investment Strategy Consulting Group at Nomura Research Institute Consulting and Solutions. Sunny has a strong track record across M&A transactions, both buy-side and sell-side, largely on the cross-border endeavors. Having worked with investment banking firms in past, his experience includes complete transaction management, business valuation, financial diligence, and negotiation roles. May I request Sunny to please come on stage? Our third panelist is Mr. Upendra Nath Sharma. Upendra is a partner in the corporate practice of a firm, JSA. Upendra's practice primarily covers mergers and acquisitions, joint ventures, private equity, restructuring, corporate commercial, compliance, and anti-corruption matters. He's part of the India's JSA's Indo-Japan practice. His vast experience augmented over the years in representing multinational corporations, especially from Japan, helps him appreciate the nuances of different sectors like manufacturing, pharma, real estate, automobiles, media and entertainment, IT and retail with same vivacity. May I request Mr. Upendranath Sharma to come on stage? Our fourth panelist is Mr. Trishit Chatterjee. Trishit is also a partner in the corporate practice of our firm JSA. Trishit's practice encompasses diverse areas of corporate commercial laws with a specific focus on cross-border mergers and acquisitions, joint ventures, corporate restructuring, and general corporate advisory. He is also part of the Indo-Japan practice of the firm and has been representing several large Japanese corporations in relation to their India-related investments and projects. May I request Trishit Chatterjee also to come on stage, please? The panel will be moderated by Mr. Amar Gupta. Amar is amongst the founding partners of the disputes practice of JSA. He focuses on international arbitration in cross-border disputes arising in joint venture and commodities contracts. He also focuses on insolvency law. He is a member of the ICC Commission for Arbitration and also serves in its National Committee for India. May I request Mr. Amar Gupta to come on stage, please?
Good morning, ladies and gentlemen. It is my privilege and honor to be here in your midst this morning. We have assembled here to celebrate the enduring bond between our two great nations. From the ancient roots of Buddhism to the modern corridors of economic cooperation, India and Japan have shared a remarkable journey, one marked by cultural affinity, mutual respect, and enduring friendship and unwavering trust. In present day, Japan's bilateral trade with India totaled US dollar 21.96 billion during the financial year 2023. While visiting India in March 2024, Prime Minister Kishida has renewed and reinforced the partnership between Japan and India. There is no doubt that both countries are committed to further strengthen economic ties and promote investment between the two countries. In this backdrop, we have assembled this panel of eminent experts to discuss recent trends in investment by Japanese companies in India and the opportunities in various sectors that India offers, including the sunshine sector. To open the discussion, I will invite Rio. Rio, for many years now, you and your firm, Anderson Mori Tomotsune, have been frontrunners in providing legal advice to several Japanese companies in their India-related investment and projects. Please tell us briefly about your experience on what you see are the trends in the last couple of years as far as the investment from Japan into India are concerned.
Okay, thank you, Amasa. So before answering to his question, I'd like to briefly explain about my experience in India. So I am a Japanese lawyer, but I have worked in India in the year of 2008 and 2009. I was working for an Indian law firm at that time. And since then, I have been closely watching or monitoring India-Japan related transactions. And with that experience, today I would like to share my thoughts about the economic tie between India and Japan. So as you may know, Japan is fifth largest country in terms of foreign direct investment into India. So apparently, our economic tie is very strong. And when I was in India in 2008, the most of investment from Japan to India is related to automobile, four-wheeled cars. And some OEMs invested in India, and tier one or tier two manufacturers followed them. However, in the recent years, the sectors changed drastically. So although the manufacturing sector is also active, I see a lot of investment in the service sector, such as education or ITC technologies. And I see even investment in startups, such as fintech or health tech. And also I see the movement about esports, which is an entertainment sector. So that's the general tendency I observed recently.
Any particular Any particular interest in the focus areas in India, such as the fabrication of chips? Indian government has been pursuing this ambition with great degree of commitment and determination. So, do you see any trends in that area?
Yeah, absolutely. That is also a promising sector. I receive a lot of inquiries about the possible collaboration between India enterprise and Japanese enterprises.
Upendra, you witnessed the entire scenario from the Indian side. Please share your insights into investment opportunities and sectors that you think are exciting in these times.
Sure. Yes, see, in the recent phenomena or in the modern world, what we've seen is India and Japan have really got great sustainability in terms of the relationships, both at the political level and the economic level. We've seen high-level summit meetings happening, investments coming in all sectors across the board, and that's been the phenomena. And about a few years back, the then Prime Minister of Japan, Abe-san, had committed about 3.5 trillion yen worth of investment into India and doubling the number of companies from Japan into India over a period of 5 years. After having achieved that objective, the current Prime Minister, Kishida-san, has committed to about 5 trillion yen of investment over 5 years, could be by a public, private sector or loans. In this background, and given the Indian scenario where the government of India is pushing for the Make in India policy, which is to galvanize and promote making of goods, manufacturing of goods in India, that with the ongoing reforms to ease for ease of doing business in India, India presents a very good opportunity for the Japanese companies to invest. During 2023, about 1.8 billion worth of US dollar investment came from Japan, which was such as transportation, pharmaceutical, drugs, telecom. And also going forward, the sectors which I see would be of great interest is the are very. Number one is infrastructure. Government has various plans in terms of, say, Chennai-Bangalore industrial corridor, sustainable development of Northeast, Delhi-Mumbai industrial corridor, and several others. So there is a lot of opportunity in the infrastructure sector. Next is energy. Energy could be hydrogen, which is the flavor of the season. It's the clean energy. And Japanese companies have a lot of know-how in that. And then digitalizing the energy is another sector where we see growth coming in. And besides this, the other sectors could be, electronic vehicles, and of course, technology will continue. And all these sectors are also encouraged by the production-linked incentives by the government of India. So if you have producing in India, there are a lot of incentives which the government provides. So given all this background, I feel there's ample opportunity for the Japanese companies to invest in India.
Ryo-san, you heard Upendra talking about the renewed interest or the deep interest in the clean energy sector. Can you tell us about some important investments, important forays that the Japanese companies have made in that area? Any particular instances? Of course, there are confidentiality considerations that you'll have to keep in mind, but subject to that, whatever information is available to the public, it will be of interest to this audience to know that Japanese companies are actually walking the talk.
Yeah, okay, thank you. Yes, renewable energy in India is very attractive place to invest. And actually, a lot of Japanese companies has already invested a large amount of money in the projects in India. I think this is public information, but some mega bank, one of the Japanese largest banks, has already have some stake in Indian mega solar company, and also some invest funds owned and controlled by some Japanese entrepreneur has also committed to invest a large amount of money in those projects. And so, the Japan has experienced some large incident of nuclear power plant at almost 10 years ago. So renewable energy is a high topic in Japan too. So there is always interest from Japan to all over the world, and especially India.
Sunny, you are an Indian working in a Japanese consulting firm, and therefore, in some ways, in some sense, you are our man in Japan. Can you please throw light on the business environment in India and tell our Japanese friends here, give them comfort perhaps about the ease of doing business and the strides that India has made in that area? And what are the initiatives taken by the Indian government, as well as the federal government, as well as the state governments, which are of interest to the Japanese investors and businesses who are looking for opportunities in India?
Sure, Ramazan. So basically, as you also said, 90 to 95% of my clients are from Japan. And very often I hear this question from Japanese companies, very common question, that India is too vast. It's too complicated for us. How shall we do business? So I want to tell all the audience here, the time has changed a lot. A lot of things India has done in last few years. If I have to start talking about few, very first thing coming to my mind is digital transformation and data-driven economy. So we have taken some of the basic yet very important steps. For example, having Aadhaar. So Aadhaar is unique identification number allocated to all citizens of India. Now, while it sounds very simple, just UID, Aadhaar number, but it support industries for any kind of verification and to avoid any paper mechanism. With Aadhaar, our Indian government also introduced DigiLocker. Now, it's actually a digital form of locker where all the citizens of India can save their government records digitally and without paying any cost to that. Now, leveraging these kind of ideas, our financial sector has boomed a lot. And foreign financial services companies in India, when they feel it is complicated to evaluate a person or an identity in a rural market or remote area, now it has become much easier. So turnaround time has decreased a lot. After that, if I talk about other things like Upendra also talked about manufacturing, and there are a lot of taxation benefits also being introduced in the manufacturing sector. I would say there also a very big step Indian government has taken, which is around setting up the right infrastructure. So infrastructure, as we all can imagine, is very much required in order to promote especially manufacturing sector. So India is right now focusing on multimodal transportation system, which includes your railways, roadways, airports, seaports. In all the areas, in last 5 years, Government of India has allocated highest ever budget allocation. So just to give you some example, in last 10 years, road network of India has increased by double the capacity. Airports have become double. The number of airports we used to have in 2014 was around 74, 75. Now we have more than 150. If I talk about railways, we have already achieved almost 98 to 99% of electrification. And now the biggest focus of Indian government is to have dedicated freight corridors just to promote local manufacturing. So these are some of the thoughts which are coming to my mind.
So these are the exciting developments, Sunny, and that's a beautiful big picture that you have painted. But do tell us that has the approach of the regulators changed? Because that's really the key concern of any business operating in India. How to tackle the regulatory red tape and hurdles and the deep control, regulatory control that is embedded in the business environment in India. So do you see any changes there? Can you report any positive development in that area?
I think this is very important question you have asked. I also started working with Japan in 2008. And I still remember my first few assignments used to be something like preparing a very long, big Gantt chart of taking multiple, maybe more than 50 approvals. And that might take 10 months to 15 months time period. And this was one of the most irritating point for most of the foreign companies, including Japan. But now when we do the same thing right now, I think it is so fast that within few days time, you can set up your entity in India and start operating. In fact, for a new entity in India, as Mr. Ambassador also mentioned, the taxation is as low as 15%. So this shows that those regulatory, whatever we used to call it as a hassle, that word has gone and is going away even furthermore. Now, with that, many state governments also took initiative that if you are approaching any state government, they have most of the state government now have created single window clearance system. So people doesn't have to run around to multiple departments to take approval. Just file your application at one window and things will be taken care of.
One remarkable development that I see is that there is a competitive federalism in India. Every state in India is competing for foreign investment, and they're trying to do better than each other. That's a great thing, and it's a marketplace for investment where all destinations should compete as they do. Turning to you, Trishit, you have worked in Japan. You have, as a part of your very successful practice, you have advised a large number of Japanese companies, and you continue to do so. You also advise US and European companies as a part of your work. Please tell us certain unique features that you have come across while advising Japanese players on M&A and joint venture. Are there any salient features that you would like to highlight vis-a-vis or in comparison with the investors and businesses from Europe and US?
Yeah, thanks, Amar. I think that's a very interesting question. So I have been advising Japanese companies for close to 15 years now. And whenever we work with Japanese clients in an India investment or a project, I think the first thing that comes to my mind is the meticulous planning that they have. I think that differentiates, a Japanese deal from any other deal, whether it is US, Europe, or any other geographies. In fact, they are so conscious of the planning aspect that the planning actually starts not, I think much way before the actual deal or the project starts, and it continues even during the execution of the project, so that it is seamless and smooth. And this is one of the aspects which is a great learning for me as well, because we as a law firm, I think whenever we advise our Japanese clients, we keep this in mind, and we have been successfully doing this for all the transactions and projects that we have been advising. So that is, I think, one aspect. The other aspect, I think, which is different from US and European clients is that Japanese are generally risk averse, and especially in a foreign jurisdiction, they do not want to get into unnecessary disputes or controversies when they are doing business in India. I think typically what happens is that when a Japanese company acquires an Indian company or they enter into a strategic alliance, joint venture, so many of the Japanese expatriates, they become directors and they are key managerial personnel in the Indian joint venture company or the company that they acquire. So obviously there is a lot of responsibility on them, and they do not want their representatives who are in India to get into unnecessary legal issues, or for that matter, any other risks, whether it is business, financial, commercial, etc. The third aspect, which is, I think, which came to the forefront very clearly, was during the COVID times. So we always heard and we know that Japanese loves to meet their partner in person and have discussions face to face. This kind of, I think, took a turn during the COVID for obvious reasons, that there were not, much scope for travel, and therefore they could not travel to India. They could not see, if it was a manufacturing facility, for example, they could not see the plants, the manufacturing facilities, and hence I think Japan-India deals, reduced to a considerable extent. Whereas I think during the COVID period, the US and European players took fair bit of advantage, because I think deals were happening and assets could be acquired at a very good valuation, which I think the Japanese possibly missed out on. But having said that, I think the last year, especially the last 6 to 8 months, the Japanese have bounced back, and we see a lot of deal making that is happening, and there is a lot of interest by Japanese companies to acquire businesses in India.
Thank you, Trishik. Given the limited time I have, I would request the panelists to keep their answers brief going forward. Ryo-san, as a Japanese lawyer, what are the key areas of concern for a Japanese company when they look to invest in Indian market? What are the red lights that you'd like to flash for companies which are going into India?
Okay. So the first concern would be the tax and dispute, which JSL will talk about that today. And so why tax is a concern? Because if you have an entity in India, you will have like 4 or 5 tax disputes in a few years. So the tax authority is very active in India, and sometimes it is more active than Japanese tax authority. I heard that if you go to the first forum of the dispute in addition to tax, you have a chance to win the case almost 60%. So that means more than 50% you have a chance to win the case. So it may be a little exaggerated, but still you have a good chance to win the case. So if you enter the Indian market, you should be ready for engaging in such kind of disputes.
Upendra, any cultural nuances that you'd like to tell us about? Some interesting anecdotes?
Sure. See, sorry. In India and Japan, our relationship goes back centuries, during the Buddhist times, as you also mentioned. But over the years, both civilizations everywhere, there's some changes. While there are a lot of similarities between Indian and Japanese companies and operations, but there could be some cultural issues that one needs to be mindful of or be aware of, I would say. It's nothing very different from what Japanese would also like. First one I would think is depends who's your counterpart, target, or transaction that you are dealing in India. Are you sector or the private sector? Private sector could be a little bit more faster in taking decisions, whereas public sector may take a little bit longer. It will still decide and move on. The only thing is that there could be central government involved, there could be state governments involved, or both the governments, those kind of things. And socio-economic impact of the project has to be studied. So, undertaking those kind of projects may take a little bit longer. Then next point would be that please study the Indian market. Is your product or service, priced right for the Indian market? Indian market is growing very strong over the years. There's a strong domestic market and great competition within the country and from outside the country. So you have to analyze the market first. Does it suit your requirements? Third would be, which Trishit also mentioned, that the Japanese like to go and meet in person. I think even Indians want that. They would love to do that and they prefer that. So make trips to India, visit your prospective counterparts, make conversations. Before you start the business conversations, maybe have some, light conversations. Cricket, Bollywood, India is very popular. Maybe just anecdote of that eases the temperatures or the atmosphere in the room. So that's important. And then also study, is your counterpart really has the right vision which you look at for? So, those kind of things have to be implemented. And another thing I would say, I will not take more time, is that Indians have a habit of not saying no. So it's not easy. They will just say, okay, we will see, we will come back. Saying no is not so that very common. So study the body language, study the thing, and after your meetings are over, write down, exchange mails so that people understand where we stand. So those are the things that one needs to be careful of.
So in a meeting with an Indian, just keep a watch just carefully on which way the head nods.
Yes.
Okay, Trishit, any significant trend that you see after COVID, recovery from COVID, between in the business transactions between the two countries?
Yeah, so as I said, I think acquisitions and deal making has become very vibrant, and we are seeing a lot of activity that is happening between Japan and India. As far as another trend which Okuchi Sensei also pointed it out, apart from the large strategic M&As that we have seen and Japan is known for, we are seeing a new trend of CVCs or corporate venture funds and pure play venture capitalists, capital funds. They are also looking at the Indian startup and tech ecosystem in India. We hear, players like, of course, we have heard about SoftBank for many years now, but apart from that, I think Mixi, Global Brain, Advantage Partners, we are seeing some of these funds which are, and I believe that they would be looking at India closely. In terms of the shareholding, I think we are looking at buyout deals, but at the same time, many of the JVs and other deals, I think they are acquiring 25% or below with an option to go beyond those shareholding percentages in the future, depending on, I think, the performance of the Indian company. So, but overall, I think it's all very good. We see exciting times between Japan and India.
Sunny, the last question to you. Are you able to identify some key factors or key insights into what would make a Japanese investment in India work?
Yeah, sure. So let me share three interesting strategies here. First one is that I want to compare India with Southeast Asia. I know love of Japan for Southeast Asia, So point here is if you can get a good success in Southeast Asia, then you have much bigger opportunities in India. To state some facts, top 20% income population of India is equivalent to 40% of income of overall population contributing of all Southeast Asian countries together. So you can imagine the vastness of our country. And likewise, if I talk about these two geographies, number of listed companies in India are almost 2.5 times than the number of listed companies together in Southeast Asia. And third is uh, companies having more than $1 billion revenue in India is 3 times than the companies of similar size in Southeast Asia. So we know in India we have around 8,500 Japanese expat, but you'll be surprised to know there are almost 20,000 expats from Japan in Indonesia and Vietnam individually. So after that, second one, cluster approach. As I said, many people feel in Japan, India is complicated country. So don't focus on pan-India presence at one go. You can follow a cluster approach. So point is, neither plan pan-India, nor just plan only major cities like Delhi, Mumbai, Chennai. You can focus on one city, let's say Delhi, and 100 kilometers of Delhi, if you cover, it will give you 10 more cities to cater. And that would be as good as one country in Southeast Asia. And the last one and very important one is about the management. So basically, immediately after investment by a Japanese company into an Indian company or a greenfield entry, there is a Japanese expat who's running the show as CXO. Now, there is nothing wrong in that. The point is, we know almost 95% of Japanese companies in India, every 3 years, there is a shuffling. That CEO go back, a new person come, and then they start understanding India from zero. So in order to avoid this transition, maybe a dual management structure can be followed. Like some of the important roles by Japanese top manager and some of the important functions by India top manager. And we have success examples. For example, Suzuki. So the entire sales and marketing is being led by India head and the entire operation and manufacturing by Japanese head. Likewise, in case of Daikin, the managing director is Indian. Panasonic chairman is Indian, who's taking care of entire business development, and managing director is Japanese. Unicham, another success story from India. So exactly same is the structure they are following.
Very interesting. Much as I would like to continue this conversation, it's like everything, a good thing, it must come to an end. With this very interesting comment from Sunny, I close this session. The panel discussion is, thank you very much, panelists, for your very insightful answers. And ladies and gentlemen, if you have any questions, please wait for the lunch hour, and you can ask your questions to the panelists directly. As the next item on the agenda, I will invite Kumar, our partner at JSA, to present a brief overview of taxation of investments from Japan to India. He's a partner and head of direct tax practice at JSA. Kumar is a qualified chartered accountant and an advocate practicing taxation for last 25 years. He has extensively dealt with cross-border taxation matters and has worked on structuring of marquee M&A transactions, tax policy matters, and tax litigation and representation. He'll now take you through the key tax issues to be considered while investing in India. Over to you, Kumar.
Thank you, Amar. And it was a great session. Thank you all. Next slide, please. So before I start, I just want to add a little bit of my thought process on what Mr. Ryo Okochi said on the dispute resolution. So we have now a much lower disputes for three reasons. The smaller, tax issues are pardoned. So essentially, the government has decided that they will not pursue those litigations. That's one. We also have what we call as an advanced pricing agreement regime, where the transfer pricing disputes are pre-settled and it's quite advanced. More than you can say 100 APAs are done, both bilateral as well as unilateral now. And the third issue is that we now have a faceless assessment regime. It means that you don't really need to run around an officer or any other income tax department person to give you a refund, or for that matter, you don't even require someone to go and run around and take your case with the officer on a regular basis. So these are some very very marquee things that have happened in the Indian tax regime in last few years. I'll now take you through the other issues. So primarily from an Indian investment perspective, we have exchange control issues and the Indian tax issues, leading the analytical part of it. I have just basically two things, but if you really want to know what is it that you need to do, we have an FDI regime which tells you that you can have a presence. Next slide, please. You can have a presence in India by way of either a branch office, a liaison office, a company, or an LLP. And all three of them have different tax attributes, all four rather, because liaison office is also there as an option, but it's just for the information exchange purposes. We have the all four governed by FEMA. Essentially, if you have to set up a branch, only a few things that can be undertaken in case of a branch, and there is a list at the end of it. Liaison office is only for information exchange. An LLP or a company is an entity which is primarily an operating entity. You can invest into those ones, and most of the investment actually goes into a corporate or a company. You can have a private limited company set up in India. You can also have a public limited and eventually a listed entity set up in India. And there are many, many successful joint ventures which the Japanese companies have in Indian context and which are there in the public, which are publicly traded. It's pretty well known now. Next slide, please. So income tax is the area which one should really know. We have a basic categorization of a non-resident versus a resident in India. A resident, as in case of all other countries, is taxed on the worldwide income. Non-resident is taxed only in respect of the income which accrues or arises in India. And that income essentially is, you can say either you're receiving an income in India if there is a royalty or an interest, or for that matter, if there is a business connection that you have in India, all of that will be considered. We also have in India Japanese tax treaty. So the Japanese companies will can benefit from the lower tax rates, which are enshrined in the tax treaty. And at the same time, they will also get the credit for the taxes that they pay in India when it comes to these income streams. India also, as just mentioned before I start the presentation, India also now have detailed transfer pricing regulations. In fact, very interestingly, transfer pricing regime was something which was, if you look at historically, it was Japanese companies which were supplying to US, and that's where the whole transfer pricing regime was actually historical from a tax history perspective, started coming in. So there's a learning which which we have in India is essentially from the Japanese jurisprudence when it started all. But now India jurisprudence as well is quite nuanced. We also have capital gains tax on the investment if you were to sell those investments in India. So primarily we'll deal with how those income streams are taxed and reflected. Next slide, please. So the residential status of a company is decided on the basis of where it is incorporated, or for that matter, where it is managed. So if it has a place of effective management in India, even then it can be regarded as a company which is resident in India. But then we have to go to treaty and look at the tiebreaker clause and see where its primary economic benefits or economic presence is can be stated. or for that matter, where it is managed. I think that's the correct term here is POEM, place of active management. One would need to figure that out to find out where it is a resident of. A company which is a subsidiary company of a Japanese company is considered to be a resident of India because it is incorporated in India. It is assumed that the company will be managed from India. Even if the entire board of directors of an Indian subsidiary of a Japanese company is in Japan, the company is nevertheless regarded as a resident of India for tax purposes and has to pay the local taxes here. The tax rates in Indian context are primarily now two. For a new manufacturing entity, the basic tax rate is 15%, which effectively, with all surcharges and all, turns out to be 17%. For any other company, if it's not really into heavy subsidized kind of business environment, or if it's not taking certain concessions, the tax rate is 22.17%. So effectively, these two tax rates are the key taxes. The basic Indian companies are also subject to tax at 30%, but that is where they are not really availing this concessional benefit here. Power generation. I think someone in the audience also mentioned about the power generation. So even a power generation company is also entitled to the manufacturing tax rate, which is quite lower. The non-resident, the difference between tax rate in terms of whether when you're operating like a branch versus when you're operating like a company comes when you operate as a branch, your tax rate is 40%. But when you operate as a company, the tax rate is 22%. And there is also a tax when you repatriate the dividend. So it's like both put together, will be somewhere around 35-36%. But if you're operating as a foreign company, like a Japanese company in India, then the tax rate is 40%. Next slide, please. As I just mentioned, the branch is regarded as a permanent establishment, and it's taxed at the higher rate than in comparison to an Indian company, or for that matter, even a subsidiary of a Japanese company in India. The key issues that you must really know. Suppose if you are a supplier from Japan to an Indian entity, the fact that you supply under the Indian Income Tax Act, if you have some kind of an agent or a little bit of presence or a distributor in India, it is possible, and one can really check that out, whether it can be regarded as having a business connection in India or not. So purely under the Indian Income Tax Act, it is possible that you may be considered as having a business presence by way of a business connection in India, and that is good enough for you to really pay taxes in India. But here comes the treaty, and in case of if you're qualified to be a tax resident of Japan, then you are taxed only when you have a permanent establishment in India, and your income is actually attributable to that permanent establishment. Otherwise not. You also have to be mindful of the fact that there are certain tax registrations that we need to take, which is PAN, which is permanent account number, tax deduction account number, and all. And once you obtain some of these registrations, PAN is required for ensuring that you get the credit, and also for making certain filings in India. TAN is required only when you are required to withhold some tax. Next slide, please. I think we've just discussed the different ways in which you can operate. Here is a depiction of the very same thing. There are 4 income streams that are generated: dividend, interest, royalties, and then capital gains. We'll look at the taxation of these in the next few slides. Next slide, please. So these are the 2 columns that effectively tell you the different tax rates under the local law as well as the treaty for these income streams. And you can see that significantly this is lower in the treaty. Next one, please. We have, even in terms of capital gains, the good part is that whether you are investing into an unlisted company or a listed share, a long-term capital gains tax is only 10%, while in case of a short-term gain, a foreign company would still be required to pay tax at 40%. In fact, in my own career, I have rarely seen anyone paying short-term capital gains tax. So it's only for the name of that there is a high tax rate there, but it's not really something which really people end up paying. Yeah, we can move next. In case of foreign portfolio investors, even the short-term capital gains tax, when they're selling the shares of a company which is listed in India, turns out, reduces to 15%. So effectively, there is much better, you can say, benefit if you are essentially getting even the short-term capital gains tax in case of the listed companies. Okay, next slide, please. Okay, so these are the activities which a branch office can undertake per se. I think more or less we are covered. And may I invite Amar Gupta for his next session on the dispute resolution mechanism in India.
You will have to put up my slides. Yes. Thank you, Kumar. I'll try to be brief as much as I can. India has a well-established and very sophisticated court system for enforcement of contract. It has also introduced a legal framework for alternate dispute resolution through arbitration and mediation. In 2016, India brought in a new statute for debt resolution, debt and insolvency resolution called the Insolvency and Bankruptcy Code, which provides for swift resolution of the debts of insolvent companies, or if that fails, then liquidation in a time-bound process. Next slide, please. So far as the Indian judicial system is concerned, there is a hierarchy of courts, and Indian Constitution, by specific provisions made in the Constitution, guarantees independent judiciary and a rule of law. There are detailed framework which compare well with very advanced nations of the world in terms of guaranteeing independent judiciary and due process and rule of law. Next slide, please. The hierarchy of courts in India is laid out in this slide. You have Supreme Court of India on the top. Below that, the High Court in every state or province. And underneath that, the High Court, subordinate to it in the judicial hierarchy is the District Court, which is generally the court of first instance. There are some states where the High Court also is the first court of first instance if the High Court has what is called the original jurisdiction. And in those high courts, an action or a proceeding can, as a matter of first instance, be brought in the High Court itself, depending on the value of the dispute. Besides the courts, there are specialized tribunals, such as the National Green Tribunal, Intellectual Property Appellate Board, Telecom Dispute Settlement Board, Appellate Tribunal for Electricity, and most importantly, National Company Law Tribunal and the Appellate Tribunal for administering the Insolvency and Bankruptcy Court and the Companies Act. Next slide, please. For businesses, the most effective mode of dispute resolution is the alternate dispute resolution through arbitration. As a pre-arbitration procedure, there is a legal framework available under the Arbitration Act for conciliation. India has also introduced a special statute to provide a formal framework for mediation process. This statute was brought in 2023. Next slide, please. The Arbitration Act in India is almost 2 decades old. There has been a series of court decisions which has interpreted the provisions of the Arbitration Act and brought it in accord with the international jurisprudence in arbitration. There have been a series of amendments that the Indian government has brought to make the act more workable, more friendly, and supportive to arbitration process. The salient features of arbitration in India is the time-bound resolution of dispute. There is specific provision made in the statute through in form of sections 12, 13, and 14 to ensure there is no bias in the tribunal which adjudicates the disputes. There are very limited grounds to challenge the arbitral award. For awards made in India, the award can only be challenged under Section 34 if it is contrary to Indian public policy or there is a failure of due process or opportunity to represent the case. There is also provision made in the statute for recognizing and promoting the institutional arbitration. There are national institutions which are already in existence, such as the Mumbai Center for International Arbitration, Delhi International Arbitration Center, and local centers in some of these states who are accepting cases for adjudication. International institutions such as ICC, SIAC, LCIA also conduct arbitrations seated in India, and therefore a Japanese business carrying on business in India can choose one of these international institutions, arbitral institutions, to conduct arbitrations in case the disputes arises with his partner in India. Next slide, please. The enforcement of domestic arbitral award is fairly simple. The award holder, the party who receives an award, has to wait for a period of 3 months for any challenge to be brought. And if a challenge is brought, then the stay of the arbitration award is not automatic. The stay has to be granted by the court by a specific order. That's a new change brought into the act. And once the challenge proceeding has been concluded, if the award has not been set aside, then the enforcement can be undertaken immediately. And enforcement of award is as a civil decree of the court. So the procedure and the method of enforcement of an arbitral award is quite similar to a decree of a civil court. The statute treats the arbitral award at par with a decree made by court. Next slide, please. For enforcement of foreign award, the statute provides a separate chapter, and the challenge to the foreign award is only available in the country where the award was made. A challenge to that award cannot be brought into India, and this is a reform done by a judicial decision by a bench of 5 judges of the Supreme Court in the famous case of Balco. India is a signatory to New York Convention as well as Geneva Convention, and the enforcement mechanism for foreign award is quite consistent and in line with the provisions for enforcement under these conventions. In India, once the award is brought for enforcement, there are certain formalities required to be fulfilled, such as filing a certified copy of the award. There is a provision in the chapter governing the enforcement of foreign award, which provides for raising of objections on certain very limited grounds. One such ground is the ground of public policy. The jurisprudence which has developed with regard to the understanding of the expression public policy is again quite in line and consistent with the jurisprudence worldwide. The understanding of the term is quite similar to its understanding elsewhere in the world. So you don't need to worry about long drawn litigation for deciding the objection to the enforcement of to the award. If the objection against the enforcement of the award is accepted and the award is not enforced, the court declines to enforce it, there is an appeal provided. And generally, the court process is far swifter, and because there are commercial courts in place, which I will talk about in the later slides. Through a series of decisions, the Supreme Court and the High Courts have taken. Can you move on to the next slide, please? The courts have taken a very pro-arbitration stance and lean in favor of supporting the arbitration proceeding and enforcing the arbitral award, and rule against it in rare exceptions. The Supreme Court has issued injunctions to the court to decide these matters swiftly without any undue delay. It has also warned and cautioned the courts below to not act as appellate court, and by its own decisions, the Supreme Court has well established the principle of minimal interference in arbitral award. Next slide, please. India has also introduced the Commercial Courts Act in 2015. This has established commercial courts in the district courts and the commercial division in the High Court, where the High Court has the original jurisdiction. The Commercial Courts Act has two salient features. One is the time-bound decision on various matters, and the curtailment of the right of appeal. The right of appeal, as which is available under the Civil Procedure Code, has been significantly curtailed in respect of proceedings in the commercial courts under the Commercial Courts Act before a commercial court. In the High Court, in the appeal against an order passed by commercial division is available through an intra-court appeal to the commercial appellate division. For the commercial courts at the district court, the appeal is available. The first appeal is available to the commercial division in the High Court. Next slide, please. One more very important legislative reform that has come about in India is the introduction of Insolvency and Bankruptcy Code. The code was brought in 2016. The code provides for pre-packaged insolvency resolution process for micro, small, and medium enterprises. It also provides time-bound procedure for resolution of the debt. It is a creditor-driven process. The code prioritizes the rights of the creditor, providing them with a clear legal framework to recover debts in a time-bound manner against the earlier legal framework. Through a series of decisions, Supreme Court has evolved what is called the clean slate theory. The court prevents any past claims from resurging and thereby throwing into uncertainty amounts payable by a prospective resolution applicant who successfully takes over the business of the corporate debtor, meaning thereby if a company is acquired or taken over by a resolution applicant through a bidding process, and once the resolution applicant has taken over the company, he will not be there's no scope or potential for surprise claims and claims which had not been previously raised and litigated. The code also provides for avoidance of transactions done in the past. There is a look back period between 1 to 2 years, depending on the category of the transaction. The transactions for which this provision is made is preferential transaction, undervalue transaction, and transaction to defraud the creditors. With that, I come to the end of my presentation. If you have any questions, I'll be happy to answer those during our lunch. Thank you very much. I will now invite Upendra. Upendra? Yes.
Thank you, Amar, for that insightful session. I think that's quite educative to understand how the Indian legal system works. And it certainly is, there's a rule of law and there's a proper arbitration process as well. And with that, we come to the end of these presentations and sessions. Request you to please join us for lunch, which is in the outside foyer area. And in case there are any questions or answers, we'll be more than happy to answer those. Thank you.